proceed.
For the record, your name is Brittany Kelso, ma'am?
Yes.
And your employment?
Oakland County Children's Village
How long have you been employed there?
for 3 years.
Ms. Kelso, am I correct in stating the Children's Village is the entire grounds of the facility? Am I not correct?
You are correct.
And then there are parts to it.
Yes, ma'am.
There are a number of buildings, and they used to be designated by letters, correct?
Correct.
In fact, one of those buildings is the Mandy's Place. Yes?
Correct.
I'm
Yes.
sorry.
Yes.
Okay. Mandy's Place used to have, I believe, an H designation,
Correct.
and then it was renamed by a young lady who passed away.
Correct.
There are secure buildings within Children's Village, correct?
Correct.
And there are non-secure buildings within Children's Village.
Correct.
Mandy's Place specifically is not secure, so it's called a non-secure facility.
Correct.
When someone approaches Mandy's Place, there is a double door, is there not?
There are 2 doors to get into the area where the children are, yes.
Okay, so the first set of doors is a double door, correct?
The first set of doors is 2 doors that would swing open, yes.
And they appear, I don't know what they're made of, but they appear to be a wooden door, almost like a house.
The first set of doors are metal with glass. The second set of doors are wood.
Okay. And also double.
Yes, ma'am.
And then when you enter Mandy's Place, there's like a vestibule area, is there not?
Correct. Through the first set of doors are 2 offices. And then after that is the wooden doors you're referring to that open to where the children are.
Okay. And there is a girls' wing as well as a boys' wing.
Yes.
Are both wings pretty much the same to the extent that they have some private rooms, some double rooms, and some 4-person rooms?
On each wing, there are 6 single rooms and 2 dormitories.
In the Mandy Place building, are there any jail cells? In other words, any rooms with any kind of bars on them?
No.
Are the rooms, well, describe the rooms.
Would you like me to describe single or the dormitory room?
Start with single.
The single room has a wardrobe, what could have hanging clothes in it. There's 2 drawers in there for socks, underwear, other types of clothing items. There's a rug in the middle of the room. And
Are the
then
rooms carpeted?
they are not carpeted. However, there's a very large rug in the middle of each single room. And then there are twin-size bed frames with a twin-size mattress that then the bedding is placed on it when the child goes to bed.
And either double or the quad rooms?
The dormitories can hold 6 twin-size beds, so 6 residents, 6 youth can be placed in those dormitories. And those also have what you would refer to as a wardrobe. It holds hanging clothes as well as the drawers. And then there's also the 6 single beds in there. And typically there is also a large area rug. However, those rooms are carpeted.
Okay. Anywhere in the building that is designated as Mandy's Place, is there privacy in the bathrooms for the children?
They're stalled bathrooms, so
Okay.
yes.
When you say stalled, are they stalls with doors on it?
Yes.
So when the child uses one of those stalls, they have privacy, correct?
Correct.
You've appeared on July 7th before Judge Gorcyca, and you went on a record, did you not?
I did.
And you made a statement as to 3 children that were placed in Mandy's place or at Mandy's place, correct?
Correct.
And for purposes of...
July 7th?
July 10th.
10, yeah.
I'm sorry if I said 7, July 10th. For purposes of this record, we're going to refer to them not by their names, but by abbreviations. So the oldest of the 3 children was 13, correct? And his name or his initials will be LT.
Correct.
The middle child was RT, and he was 10.
Correct.
The youngest child was a girl, 9 years of age, and her initials will be NT, okay?
I think
Okay.
on July 10th was 14 by July 10th. He was 14 on July 10th.
Correct, but I'm setting that, and my next question is, on June 24th, did you come in contact with all of those children I just described?
June 24th, if I recall, is when they were placed at Mandy's place.
Okay. And what was your contact with them?
That is when they came to Mandy's place, and it was discussed why they were there, and then they were placed in separate groups.
Why were they placed in separate groups?
Per the court order, they were to be separated as much as possible
From the other residents?
from each other, from the siblings.
Did you maintain the files for these 3 children?
The way, I'm the case coordinator, so the way that the file is maintained is once it is opened, once the admittance takes place, the file is kept in my office. And then once the children are discharged, the file then goes to administration.
But while the children were there from June 24th to July 11th, actually, correct? Which is when they were transferred somewhere else?
I believe it was that Saturday, yes, ma'am?
Those files were in your possession, correct?
Correct.
And there are a number of reports that are maintained with the children in those files, correct?
Correct.
Are you responsible for placing those reports and records into those files and maintaining them?
There are some reports, there are some documents that I place in the files. However, at the time of admittance, there are other paperwork or other forms that are placed into that file. So I would not place all of the forms in that file.
But once those records are placed in that file goes back to your office.
Yes, ma'am.
Did you review, you and I met at one point in time, did we not?
We did.
And in fact, I asked you to review the records and files of those children, and you in fact brought them with you, correct?
Correct.
And that was just in case I had a question that you needed to refer back to the file.
Yes.
In your review of all those files, did Mandy's Place have any issues or problems with these children?
Your Honor, I'm going to object. Your Honor, these records were provided by Oakland County to counsel as confidential under statute. This is all stuff that occurred after June 24. Whatever happened to these children in the Mandy's Place facility is irrelevant to what the judge did on June 24, and whatever the judge did on June 24 is irrelevant as to what happened under Children's Village. I see no reason why we need to breach a privilege that, or a confidentiality statute that Mandy's Place follows to get information about what might have happened after the complaint in this matter is foreclosed.
But Judge, if I may respond.
You may respond.
First of all, I haven't asked anything about those records. All I said was, in your review of the records, were there any problems with these children? That's number one. Number two, this is a...
That would be delving into, obviously, the content of those records, which are confidential. Go ahead.
If I may, this is a continuing transaction. I understand, but Judge, if I just make a record, this is a continuing transaction. This is an order that the judge had placed in effect, and this is where the children were. Although you make findings of fact and conclusions of law, this matter then goes further to the Commission as well as the Michigan Supreme Court. Part of their job is to determine sanctions. This is the only record that we will be making, and it also includes record for sanctions. That is precisely why we have the rule of 9.211 that allows for separate record, and if so, that I am asking to make that separate record.
Your Honor, the argument seems to be that if a judge sentences a murderer to jail wrongfully and that murderer gets stabbed, all of a sudden the judge has done more than the judge has done. The fact of the matter is, whatever happened at Children's Village had nothing to do with what happened on June 24, has no bearing on June 24, and these are confidential records in which, to which the children have not waived privilege, to which Oakland County has not waived privilege, and this witness has not waived privilege. The fact of the matter is, we don't need to see these records. We don't need to do that in order to determine whether the judge committed misconduct on June 24 or in her 28-day response.
First of all, this is not a criminal case. Number two, the confidentiality, when these records were requested of Oakland County, they provided it. They did ask that they be maintained confidential, and I have no problem with offering it for this court, this record, and then having them sealed and not having made part of the record for dissemination. However, with respect to making a separate record, there's absolutely nothing wrong with what I am requesting to do.
Objection sustained.
Thank you.
Did you have any behavior problems with these children?
Your Honor, again,
Objection sustained.
Ms. Kelso, did you get any phone calls from Judge Gorcyca?
I personally did not.
To your knowledge, did Judge Gorcyca make any phone calls?
Your Honor, what time period are we referring to?
Well, the only time period we're referring to is June 24th to July 11th.
After the 24th, I object to relevance.
Overruled.
Did Judge Gorcyca make any contact with Children's Village?
I believe she did with our administration.
And I understand, Judge, just in anticipation of counsel jumping up, I would like to ask a question and then offer this witness to refresh memory only part of the confidential records. Clearly, she's not going to read from it. It will still remain confidential.
Your Honor, it's still privileged.
But I'm showing it to this witness.
Go ahead.
Or can I see what you're showing to her, please?
Yes.
Certainly. Ms. Kelso, you testified that you believe that Judge Gorcyca did contact the administration, correct?
Correct.
And did you make a notation in the files relative to that contact and that phone call?
I may have.
Let me hand you what counsel had seen for the record. It is part of the Children's Village record. Do not read that into the record, please. Can you read to yourself the paragraph on the bottom of this page? I'm sorry, yes?
Yes.
And does that refresh your memory? By the way, that is your signature, is it not?
That is my signature.
Does that refresh your memory as to the contact that Judge Gorcyca had made with Children's Village?
Yes.
And why did Judge Gorcyca call and when?
Your Honor, again, these are confidential records.
No, as far as the children are concerned, I'm sustaining the objection. Judge Gorcyca's conduct is relevant. Overruled. Proceed.
Can you answer my question? Do you want me to repeat it?
Could you please repeat?
Sure.
Thank you.
Ms. Kelso, what was the purpose, or why did Judge Gorcyca contact Children's Village? And if you can testify, provide us to the date of that contact.
I believe Judge Gorcyca had contacted our administration the day the children were placed.
Which was?
I believe it was June 24th.
Do you recall the time?
It was in the afternoon. I was at a different court hearing.
Okay. I will leave this page down here. Please don't read from it. Use it only to refresh your memory. What was the time that the call was received?
Approximately 3:30.
And why did Judge Gorcyca contact the administration?
To discuss the matter in regards to the children being placed at Mandy's place and to discuss the court order.
Okay. And the court order with relationship to making sure the kids are kept apart, isn't it true?
Correct.
One moment. Nothing further.
Cross, any cross.
Ms. Calso, how are you today?
I'm well. How are you?
My name's Chris Hildebrandt. I spoke with you on the phone. I don't think we've actually met, maybe earlier today. I want to ask you about this phone call from Judge Gorcyca. You said that Judge Gorcyca called your administration, correct?
Correct.
You were not involved in that phone call then, correct?
Correct.
Are you positive that it was Judge Gorcyca, or was it Judge Gorcyca's court that contacted?
I can't be positive because I was not involved in that phone call.
Okay. So this call that was referred to starts out, or this note that was referred to starts out with per Judge Gorcyca. Does that mean to you that Judge Gorcyca called, or that it was just at Judge Gorcyca's direction?
It's per court order.
Okay, so per court order, the children were to be kept apart, correct? And we know that that's what the court orders say, correct?
Yes, sir.
Okay. But you did not speak with Judge Gorcyca.
I did not.
Judge Gorcyca will indicate that actually when Children's Village received the orders, it was administration that contacted her court to ask about separating the children. Are you aware of that?
Objection as to, was counsel testifying as to what his client's testimony will be?
Well, I don't want to have to call this witness back.
Yeah. You simply don't know who initiated the contact, correct?
Correct.
Thank you.
And so you don't know if Judge Gorcyca has ever called Children's Village herself, correct?
Correct.
Okay. Judge Gorcyca made some statements on the record on June 24 describing Children's Village. You're familiar, of course, with Mandy's place. We know that from your testimony today. Are you also familiar with J Building?
I'm vaguely familiar with it. I don't work in the secure units.
Have you ever gone into the secure units and seen what the accommodations are like?
Yes, sir.
Can you tell me what the cells look like over in J Building?
There's a door with a glassed window.
Is it a steel door, big steel door?
Yes, it's a
Locked?
big steel door. It would be locked if there was a child in there.
They didn't lock you in?
No.
Okay.
And once it's open, there are two separate types of rooms. There are rooms that have a toilet and a sink in there, and a cement slab that then there's a mattress on top of for sleeping. And then there's another room that is similar with the cement slab and then the mattress. However, there is no toilet or sink
Okay.
in that type of room.
So the toilet inside the room is visible from a window in the door?
Yes, if you were looking through the window.
And so if somebody were going to the bathroom and somebody else was looking through the window, there wouldn't be any privacy in that, right?
Correct.
Okay, and these concrete slabs with a mattress on them look very comfortable to you?
In my opinion, no.
Do they look as comfortable as your bed at home?
No.
Okay. And so to the extent somebody's describing Children's Village, there are cells at Children's Village, correct?
Correct.
And there are cells with very uncomfortable cement slab beds, open toilets, and cell doors, right?
Correct.
Now, when somebody says cell to you, we all have a picture from the movies. that show bars. But it doesn't necessarily have to have bars to be a locked cell, does it?
That could be true.
Okay, fair enough. I think that's all I have for you at this time. Thank you.
No questions?
Okay. Thank you. Ms. Kelsey, you step down, you have discussion testimony. Today, your witnesses. For the witnesses for the examiner.
Your Honor, I have no further witnesses. I would like to make some offers as to exhibits, to move to admit them. I don't know whether I had previously, so I want to make sure that the record is clear as to that. I believe that Exhibit 2 has been admitted.
I will, I'll let you know. 2 has been admitted, 10 has been admitted, 22 has been admitted, 41, 45, 46, 47 has been admitted. 138, 139 have been admitted. Others have been marked for identification only.
Okay, I would move to, I believe 152 has been admitted.
Yeah, 152 has been admitted.
Okay, I would move to admit Exhibit 140, which is the DVD of the July 10th, 2015 hearing.
Any objection? None. Be admitted.
As well as the corresponding transcript, which would be Exhibit 12.
No objection.
Be admitted.
That's all the exhibits.
All right. All right, thank you.
Examiner rests.
All right, thank you.
Run, we have a motion.
Before we do that, Your Honor, Ms. Ranieri, Mr. Bosby is still in the hallway and he is asked to be able to leave for some other meetings. Are you going to be calling him?
No, I'm not, and I did have a conversation with him just before lunch. I'll take care of it.
Please approach just for one more. All right. Mr. Crabtree, wait one moment.
Just one moment.
Your Honor, we did have a sidebar discussion as to proposed Exhibit 69.
Yeah, they,
I would move to have that admitted.
All right. Exhibit 69 is the answer that the letter. Exhibit 69, any objection to your client's?
It's a little late, Your Honor.
Pardon me?
It's a little late.
Well, are you objecting?
I am.
All right. Go ahead. You may proceed with your motion.
All right. Your Honor, is that going to be admitted? 69?
Exhibit 69 is technically, or would be an admission by a party opponent in this particular, or it's or answer. It will be admitted as an exception under the hearsay rules which apply.
All right, Your Honor, thank you.
Exhibit 69 will be admitted.
Your Honor, we're going to move for a directed verdict in this matter pursuant to MCR 2.516, which is the general motion with regard to directed verdicts, but also specifically under 9.210 capital B2 and 9.211. All of these rules relate to the handling and conducting of hearings that the master is conducting here in this particular matter with regard to Judge Gorcyca. Your Honor, even in the light most favorable to the examiner and the co-examiner, they have not established either misconduct or any type of misrepresentation by Judge Gorcyca. Specifically, I would direct the Court's attention to the standards of judicial conduct, which I think in general relate to the quantum and the level of proof that they have to establish with regard to misconduct. And with regard to 9.205, the rule states the following. Misconduct in office includes, but is not limited to, A, persistent incompetence in the performance of judicial duties, B, persistent neglect in the timely performance of judicial duties, C, persistent failure to treat persons fairly and courteously.
That's a portion of 9021, but it's not limited to, and then there's D, E, F as well.
I'm aware of that, Your Honor. But at least with regard to those that I referenced, those I think are the issues that have been raised in the formal complaint. And I would respectfully submit to the Court, even in the light most favorable to the examiner and co-examiner, that hasn't been established. Certainly there hasn't been any persistent failure to abide by these particular canons or these court rules. And even looking at the video as the Court did, that simply can't and doesn't amount to judicial misconduct. Your Honor, I think about the many judges I've had the pleasure and privilege in appearing before, and I think about the conduct of those particular judges as it relates to times and perhaps instances in which they've either been irritated with me or my client, or irritated about the situation, or simply wanting to make a particular point. That conduct, in my judgment, pales in comparison, and in fact is much more strident, certainly, than what we saw from Judge Gorcyca in that video. In essence, what the examiner and co-examiner have done, and they've done it throughout this case, is to say, Judge, we've got a video we want to show you of 22 minutes of a 5.5-year case. And once you see that, Judge, you're going to see just how exacerbated, how irritated, how frustrated Judge Gorcyca was, and that's judicial misconduct. Respectfully, that is not judicial misconduct, even in the light most favorable to the examiner or the co-examiner. This was a 5.5-year case that was building and building and building. And did there come a point in time when Judge Gorcyca perhaps was a little bit irritated, perhaps was a little frustrated, perhaps had gotten to the point where she had no other tools left in the toolbox after exhausting every other opportunity for the children to simply obey her orders? Yeah, I think so. But that cannot be, and that wasn't, and that isn't judicial misconduct. And for those reasons, I'd ask that you grant our motion for directed verdict.
Response on behalf of the examiner.
Well, Your Honor, initially I will note that the court rules that govern proceedings such as this, 9.200, and those that follow it, specifically in 9.210B2, it is specifically stated, recommendations on dispositive motions shall not be announced until the conclusion of the hearing, except that the master may refer to the commission on interlocutory basis a recommendation. So there is no DV motion as counsel would like to have this court believe or argue. Number two, he's testifying. Counsel is testifying as to 5-year-old case and what happened. There is no testimony whatsoever on this record as to what happened before June 24th, 2015. And so all we have is June 24th, 2015, and then the events that led to July 10th, 2015. And you as the master have the videotapes as well as the transcripts as well as the documents. And all we have is an order for 2 of the 3 children to appear for parenting time, and they did. The 3rd child wasn't even covered by that rule. I'm sorry, by that court order.
June 23rd order.
Correct. And now on June 24th, not only do we have violations of the law, which is contempt law by Judge Gorcyca, but also we have that tape. And the tape shows an incredible misuse of her judicial power and her behavior and what she did and what she said and how she did it and how she said it to those 3 minor children. We're not even talking about teenagers. We're talking preteen kids, 9, 10, and 13. And certainly, even if there was a directed verdict motion that was possible in these cases, this case certainly has evidence that is way beyond that and certainly is sufficient to overcome that.
Thank you. As required under 9.210, recommendations on dispositive motions will be made at the conclusion of this hearing. We'll be ready to proceed with the defendant's case in chief. Are you ready to proceed?
We are.
First witness.
If you can just give us a moment to secure the witness from outside.
Thank you. Raise your right hand. Promise to tell the truth and get yourself again.
Yes, I do.
Thank you. Would you please state your name for the record?
Lisa Renee Harris.
Thank you, Ms. Harris.
Ms. Harris, good afternoon.
Good afternoon.
Ms. Harris, are you currently employed?
I am.
And how are you?
I'm employed as a juvenile justice referee at Oakland County Family Court.
How long have you been so employed?
I've been employed for over a year now.
All right. Prior to that time, you were an assistant prosecutor in the Oakland County Prosecutor's Office. Is that true?
That's correct.
All right. For what period of time?
I was employed by the prosecutor's office from 2009 until 2015.
All right. And were you assigned to any particular area or division within the prosecutor's office?
I was initially with the district court and then with the juvenile court, where I was assigned in front of some of the referees and also assigned before Judge Gorcyca.
All right. And do you recall for what period of time were you assigned essentially as Judge Gorcyca's prosecutor?
I was assigned to Judge Gorcyca from approximately 4 years.
All right. And from when to when, if you recall?
I believe from 2011 until 2015.
All right. Judge Harris, I want to direct your attention back to August of 2014. Actually, specifically August the 21st of 2014. Do you recall that particular date?
I do.
And on that date, did you receive a call from Judge Gorcyca or a courtroom for some assistance?
Yes, I
Objections
did.
to relevancy?
The response.
Your Honor, as I indicated before, I think the court needs to understand the full context of Judge Gorcyca's actions. And what I want to focus on is what happened on August the 21st of 2014 when this particular witness recommended that there be a contempt hearing for the children. They tried everything they possibly could to get the children to comply with the court's orders and did not choose to go forward with a contempt hearing. It's just one of the many litany of things that they did in this case, Judge Gorcyca in particular, to try to simply get the children to do what they were supposed to, and that is have parenting time with their father.
Obviously, before the court is, I understand the argument which is being made that the matter which is before the court, I understand that the defense wishes to put this all in context, but as I indicated last week, is that this will not be a retrial. It's not as master, my focus is solely upon Judge Gorcyca's conduct on the 24th of June 2015. That's count 1. Whether that conduct constitutes a violation of the Code of Judicial Conduct. Sustain the objection. Thank you.
Your Honor, can I at least make a record with regard to this witness and the testimony that she would offer?
I believe you have, but you indicated that she made a recommendation to Judge Gorcyca that she held him in contempt at that point, correct?
That's part of the record, Your Honor. That's not the entire record.
You can give an offer of proof.
All right. Your Honor, the offer of proof would be the following. That now Judge Harris, at the time Assistant Prosecuting Attorney Harris, was called up by Judge Gorcyca to try to assist in terms of seeing to it that her orders were followed, her parenting time orders. And when she arrived, she discovered that the children were sitting outside of Judge Gorcyca's courtroom, locked arm in arm. She, along with several deputies from the Oakland County Sheriff's Department, attempted to literally talk the children into simply going into the jury room and having parenting time with their father as ordered by Judge Gorcyca. They were unsuccessful in being able to do that. There came a point in time where another individual by the name of Tracy Steve, a family counselor, was able to at least have the children go into the jury room, albeit to meet with their father, although they didn't have any communication or contact with the father. The behavior of the children was so obstinate and so obstreperous that Ms. Harris, now Judge Harris, recommended that Judge Gorcyca have an immediate contempt hearing. Judge Gorcyca declined to do that because she saw at least some minimal amount of progress, and as a result of that, decided not to go forward with a contempt hearing on that day, but then proceeded in several other days down the road in the months following August of 2014 to try other less severe mechanisms in terms of trying to get the children to comply with their orders.
I understand. I have read your proposed exhibits 1 through 61-ish or so, which relate to these particular events.
All right. Your Honor, with that, that would be our offer of proof. And I would also indicate to the court that we are prepared and we would also offer into evidence and would like it to be part of our offer of proof, Respondents Exhibit 77 and 78. 78 is a video of the events that occurred on August the 21st. Exhibit 77 is a transcript of the hearing of the events on August the 21st of 2014.
Understood.
All right. Your Honor, if I might have just a minute.
You may.
Thank you. Your Honor, the court just referenced the fact that you had reviewed a number of different exhibits. I think it was Respondents Exhibits 1 through 61, if I recall correctly.
Oh, let me, yeah, I've got boxes. That's correct.
All right.
Well, primarily, I believe they go all the way back, to the R1 all the way to the order of reference, judgment of divorce, all the way through, I believe 62 really picks up where the 61 is the order, your R61 is the order regarding coming back on the 24th. And then all of, I think, 60 predates, they go all the way to April 14th and reserves on contempt proceedings.
Your Honor?
Go ahead.
I'm sorry. Since the court has already reviewed those exhibits and we had anticipated offering those exhibits into evidence, I'm simply going to move for their admission right now.
Objection, Your Honor's relevancy.
I understand the court records, the court orders, the court records, and court motions. They'll be admitted.
Thank you.
Exhibits 1 through the 60. All perfect. the count one issue in your complaint.
All right, Your Honor. Thank you.
And are all court records.
Yes.
Signed by Judge Gorcyca, I think Judge Matthews and Judge McDonald and any other judge that happened to touch this case.
Your Honor, thank you.
Thank you.
Your Honor, in light of the court's order then, or ruling, I should say, I'd have no further questions for Judge Harris. Thank you.
Referee Harris.
All right. Anyone any questions?
None.
You are free.
Thank you.
Thank you. Mr. Cranmer, in essence, what I understand your objection, but in essence, what we did was submit the court file for pertinent purposes.
Yes. Thank you, Your Honor.
Which I thought would have been covered by stipulation anyhow, but nonetheless.
Did it the hard way, Your Honor.
Your Honor, respondent calls William Lansett. William Lansett is represented by an attorney who's made an appearance, Mr. Kurt Schnells. Would you like him up here, or where do you want to sit, sir?
Whatever the court pleases.
Do you think you can make objections from back there?
I'll speak loudly, Your Honor.
All right.
You should be okay.
I don't risk over here, so. All right.
Thank you.
Raise your right hand. Promise all true self to God?
I do, thank you.
Can you state your full name for me, Mr. Lansett?
Yes, William Lansat, Lansat.
Mr. Lansett, what do you do for a living?
I'm an attorney
How long have you been an attorney?
since 1985.
What is that, about
30
11 years?
30
31
years. 30 years about.
31 years, there you go.
AD or BC?
Whatever you like, whatever you like.
Are you an attorney in good standing in Michigan Bar?
Yes,
Okay. Where'd you go to law school?
Detroit College of Law,
And when did you graduate from law school?
1983.
You went to U of M before that?
Correct.
I understand that following or maybe during the U of M tenure, you were also a research associate?
Yeah, I took a year off and I was a research assistant at the Institute for Social Research on the study.
What is the Institute of Social Research?
It does quantitative analysis for surveys. It's the Survey Research Center, so to speak.
Fair enough. And then you went right into law school?
Correct.
What was your first job out of law school?
Objections to relevancy.
Your Honor, I'm just trying to get some background.
For some sort of qualification or?
Yeah, I do. Part of the argument of the JTC from the very beginning, or rather the examiner and the executive director before him, is that the people that were involved in this hearing, whether it be Michael Dean or whether it be Karen Cook or whether it be Jeffrey Schwartz or whether it be Mr. Lansett, were incompetent. That nobody objected, and as a result, they just dropped the ball. And the fact that these are experienced and well-regarded attorneys and guardian ad litems are part of our primary proofs that this was a hearing that was attended by some of the best and brightest, Mr. Lansett being the bestest and brightest of the best and brightest. And so I'm trying to establish that this is no fly-by-night guy.
The objections to stand. Right. Thank you. The focus again, I bring everybody back to my comments last week. So let's keep our eye on the ball here. All right? Proceed.
You were appointed in the Simone versus Simone case as a guardian ad litem, correct?
Correct.
When were you appointed as the guardian ad
I
litem?
believe it was August 25th, 2010.
Okay, that was very early on in the case.
I believe that was the very first motion that the judge heard for unsupervised parenting time filed by the father.
What is a guardian ad litem?
Well, under the Custody Act, the court may appoint a guardian ad litem to assist the court in making recommendations to the court on various issues that the court directs.
And you say assist the court, meaning what?
To present reports, to investigate, to go out and meet with the kids, depending on what the issues are that need to be explored.
In your experience, is a guardian ad litem appointed in every type of case?
I'm sorry, what?
And is a guardian ad litem reported in every case, or appointed in every case?
In every custody case, no.
Okay, well, when in your experience are guardian ad litems necessary?
When it's very high conflict cases, they've been to the court several times, been to the front of the court many times, they can't resolve it, judges can't resolve it, and so they try to get someone to be the eyes and ears of the court to help figure out what's going on and report neutrally to the court to help make some decisions, especially when you have maybe one parent after another, and trying to find the truth in a lot of the allegations.
Is this, the Simone versus Simone case, what you would describe as a high conflict case?
Oh, very much so.
Okay. Was this your first time being appointed as a guardian ad litem?
No.
How many times have you been a guardian ad litem in the past?
I've been, mainly for the last 20 years, I've been predominantly focusing on that with children in custody cases, neglect and abuse.
Okay. What kind of issues did the Simone versus Simone case have that required, once you reviewed it, a guardian ad litem?
I think the court felt at the time that the issues...
Objections to what the court felt?
And
The issues of parenting time, trying to facilitate parenting time with the father.
As you understood it right from the beginning, there were problems with parenting time?
That is correct.
What were the problems with parenting time that you perceived when you first came onto the case?
Objections to relevancy?
overruled, proceed.
When Judge Gorcyca appointed me on that Wednesday, she appointed me the guardian ad litem, and she also asked me to please go out. She granted the father's petition to change custody, the father's petition for unsupervised parenting time from Wednesday, I think, to Sunday. And so she knew that the mother was very upset.
Objections to what the judge knew?
Sustained.
Okay. And she helped me to facilitate the parenting time for those 2 days.
Okay, and so these particular parents needed assistance with directing or scheduling parenting time?
Correct.
Okay. How was parenting time accomplished in the beginning?
Well, it was at the park. It was Wednesday.
Well, but before that, was it all coordinated through your office?
It only began to be coordinated through me on the 25th of August.
Okay, from that point forward, it was all coordinated through your office?
In various machinations, correct.
Okay. Now, were there always problems with parenting time when parenting time came about?
Oh, yes.
What kind of problems existed?
The children would not make eye contact with the father. They would not talk with him. They would not acknowledge him. They would not touch the food that he ate or presented to them. They would not listen to him or some of the supervisors. They would try to fight him.
This is right from the very beginning?
The right from the very beginning, there were about 2 days of unsupervised parenting time. After that, Friday, Saturday, I was receiving various calls from police, etc. The parenting time was going bad. The kids wouldn't go. They were fighting the father, and mother would show up at the parenting times till eventually I said on Saturday, it needs to stop. Meet me in my office on Sunday.
They had these problems even though Natalie at the time was just 4 years old, and I'm sorry, NT was just 4 years old, RT was just 5 years old, and LT was just 7 years old.
Correct.
And they still couldn't communicate or come together with parenting.
They were fighting him terribly.
Okay, let's just consolidate the first 4 years of this case then, generally. I don't want to go date by date,
Right.
motion by motion, order by order.
I think I got that in Exhibits 1 through 16.
I agree. They've already been entered. And so I'd like to ask you what the court and the GAL, you as the GAL and the court, did to try to improve parenting time during these first 4 years.
Objections to relevancy.
Yeah, those efforts, you may proceed. Those efforts are set forth many times in the orders.
Well, Your Honor, it's true.
But go ahead, Mr. Lancer, you go ahead and kind of summarize.
Okay, thank you, Your Honor.
I've got the family bridges, I got the wizard, I got the skyport.
Well, you certainly have orders that say that, Your Honor, but there was a lot more that was done, actually.
We got his report. Go ahead.
Okay. It is outlined a lot in that report. We have tried from the very beginning various different options at parenting time with supervisors. We've tried the zoo. We've tried the school. The father could not pick the kids up from school. They refused to go with them. That didn't work. They wouldn't go with them to the zoo. They wouldn't go with parenting time unless there was a dog present in the car. We've tried the library, and when we finally got the kids to the library, they would not talk to him, they would not look at him, they would find things to distract and absolutely have no contact with him. And this happened at restaurants and everything else. Then the court tried forensic assessments. We had a forensic assessment on custody and parenting time. Then we had an extensive parenting time assessment report done. Then we tried a nationally renowned expert out in Ann Arbor. That didn't pan out. Then we tried various therapists. That didn't work.
How many therapists?
Well, we had about 3, and for about 8 months we had about, I think it was about 3, and then we had a therapeutic parenting in Mother's Home, which took about a year. She was there 8 months, and that didn't work. So,
Was there anything that the GAL, the parties, or the court came up with in those first 4 years that facilitated parenting time between Mr. Simone and his minor children?
yes, we tried to have that, but it never worked.
It never worked.
It never worked.
Okay, so why didn't you give up?
I would never give up, and neither would the court give up, because the court knew
Objection as to what the court knew.
I would never give up, because it's a constitutional right to have a parenting time and a relationship with your parents. That's in the statute in the state of Michigan. It's an inherent right of the children to have a relationship, parenting time, absent certain circumstances, with a mother and a father.
Is it also the father's right to have parenting time with his minor children?
Both parents. And that's
Okay.
an inherent right of the children. And to give up would send a horrible message to the children that we are not going to try and stop some of your behaviors that we have noticed, which were very disturbing over the years, to allow this to continue.
What kind of disturbing behaviors?
A lot of the disturbing behaviors that I witnessed, was the fact that the children would huddle together en masse with their hands, and they're all together, all 3 of them would be together. The older boy would be tapping his feet, as if he were sending some kind of messages. They wouldn't make eye contact. They wouldn't acknowledge anyone. It was very, very disturbing. And it was also very disturbing behaviors when they were with their father.
Okay, so they would do this whether their father was around or not, or was it just when their father was around?
No, with their father.
Okay. And so, after trying every machination of parenting time, and after trying all of this therapy and therapeutic parenting time, we didn't come to any better resolution by the time August of 2014 comes around, correct?
Correct.
Okay. At August 2014, I understand that the court has already indicated that we can't talk a lot about it, but there's jury time at the courthouse that also did not go very well. Is that correct?
Correct.
Okay. We've already made an offer of proof through Ms. Harris's testimony as to what occurred that day. I know that you were present, and I know that you would have a number of things to say about it as well. But after August 20th, or after August 21 and 22nd did not go well, what were the next steps that you took?
I did a detailed report to the court, outlined everything from day one to that incident in August, attached some reports to it, went through everything, and said to the court that, Your Honor, we have really tried everything here. Nothing seems to be working. We need to take some kind of draconian approach.
We'll
Your
talk
Honor.
about the contents of the report after we identify
Okay.
the report. I've just shown you what's been marked as R43. That's already entered into evidence
Okay.
through the offer of proof
It's
that we
November
did.
12th.
I'm sorry?
It's your November 12th report.
It's your November 3 report pending a November 12 parenting time hearing, correct?
Correct.
Do you need this copy, or do you have a copy with you?
I have a copy.
Okay, fair enough. Is this the report that you referred to as providing to the court relative to the children's behavior?
Correct.
And what was the intent of this report?
The intent of the report was to outline to the judge from day one my involvement, to give her a summary of everything that's gone forward in this case, and to show every effort that we have tried to do, and that there has to be a next step.
Okay. You said that you provided the full history, but then you made some recommendations. What recommendations were made to the court relative to repairing this parenting rift between Omer Simone and his children, his minor children at the time?
May I refresh my memory and just look in if I may?
Please, as much as you need to.
I think in there was to try a different type of arrangement for parenting time, to try to get the children placed directly in father's car with the supervisor, and even if it had to, in exchange, had to be the courthouse, that was one option to do. And the other one, again, would be to have the judge take an action here, because it doesn't seem like nothing worked.
Have the judge take action, you say?
Correct.
You say draconian measures, actually. What do you mean by draconian measures?
Thinking outside the box, I really didn't put in there what it was. All I know is that the status quo and continuing this and the behaviors of these children, that's had to stop.
Now, you had already described those behaviors as disturbing behaviors, correct?
Very much so.
Okay, and you described those disturbing behaviors in pretty great detail in your report, do you not?
Yes.
Okay, do you believe that everything in your report is as true today as it was then, at least as of that date? You haven't found anything in the report you need to amend or change?
No.
Okay, and you described the children huddling en masse. You described the children communicating to each other by tapping their feet, or by did you say vibes?
Right.
Okay. How did you describe that in the report?
It reminded me of the Manson phenomenon, where the girls would be indicating in trial that they were hearing voices from him or taking their cues from him, and they would be sitting together with their feet. It was that type of behavior that I wanted to describe so blatantly to catch somebody's attention. I have never seen for 30 years behavior like that from children.
Manson is a strong reference.
Right.
When you talk about Manson, everybody understands what you're saying. And these are your words in this report
Right.
to the court.
Correct.
And it refers to this sending of vibes like the followers of Manson testified to during their trials long ago.
Absolutely.
Okay, and so since the issuance of this report, has that Manson reference become kind of a shorthand, become a kind of a general reference among the parties and the attorneys and the court?
Well,
You heard that referred to before?
I heard it referred to in the contempt hearing.
Okay.
And it
and
might
so
have been referred to in another hearing.
when you were in the contempt hearing on June 24, and I understand, let's go with June 24 for a moment then. Wait a minute.
From November of 2014.
No, I'm not going to do that. I'm not going to jump from November of 2014. Following that report, there was a hearing on November 12, is that correct?
Correct.
Now, it's my understanding, I've watched the video on that day, the court really didn't make any rulings on that record, but there was a stipulated order entered into by the parties, is that correct?
Objection as to the form of the question. We have two questions.
Sustained. Drop on.
Okay, on the November 12 hearing, do you remember the court making any rulings?
I have all the orders with me, if I may just...
If you look at the November 12 order,
Yes, thank you. I think I have it here.
This is your 44.
it is our R44, but I don't think that Mr. Lansat has the marked exhibits.
We'll just give it to him.
Well, if I do that, Your Honor, then I'm not going to be able to look at it ourselves.
Mr. Lance?
Oh, thank you so much. Yes, I think that I did. Oh, a little different. Thank you, Judge. If I may just look at it one moment. Thank you.
Good luck reading your writing.
I don't think this is my writing. Correct. They had adopted my recommendation as to the template for the parenting time in that order.
Okay, so this particular order actually sets forth that parenting time was going to move forward, exchanges were going to happen at the courthouse with a deputy present, correct?
Correct.
What was the purpose of having exchanges at the courthouse with a deputy present?
Just another layer of...
Relevance, Your Honor. All this has been admitted.
Well, Your Honor, here's what I'm trying to show.
Go on.
Okay, you know what I'm trying to show.
I know.
Okay. Okay.
Go ahead.
another layer of security to make sure that it happens so nobody plays any games, and that maybe the allure of a courthouse might get people to do what they're supposed to do.
And so this is one of the steps that the judge and the parties are trying to take in order to, again, get this moving forward. One of these new measures you've recommended, one of these draconian measures, as it were, to try to improve the children's behavior, correct?
Objection as to the form of the question. That question included as to what the court intends to do.
All right. And so this was a court order that implemented the requirement that implemented one of these draconian measures, one of these outside-the-box thinking things, correct?
Correct.
It doesn't happen very often that people have their parental exchanges at the courthouse with a deputy present, does it?
No.
Have you ever seen it in any other case?
No, I don't recall.
Okay, so this is unusual. This is draconian. This is taking control, correct?
Yes.
Okay. Now, from that point, the next time that the parents are in front of the court on a parenting time problem, I believe, is March 2nd. Is that your understanding as well?
Right, I believe that was
March 4th.
on the show causes that were filed.
March 4th.
Correct.
Do you recall that hearing at all?
I was at every hearing, so I know I was there, yes.
Okay, can you tell us what happened on the March 4th hearing?
That's when we discussed the contempt issue. I believe it was on that date, because the parenting time, I may get that. Can I double check?
You are confused, so go
Okay.
ahead and double
The March
check.
4th?
March 4th we're talking about.
It's a different one. Thank you.
The order to show cause is 449.
Correct.
It was set for March 4th, 8:30.
David?
One.
R49.
Then R50 is actually the order.
March.
R50. No, I'm
The
sorry.
R50 is the order. It simply adjourned March 4th to April 14th.
Yeah, I have, Mr. Hildebrand, I have the March 6th order,
Pardon me, I've got a March 4th order right here.
and I apologize.
Exhibit
R50, exactly.
Your Honor, may I look at that moment, please?
It's already been admitted into evidence, so go right ahead.
Okay. Yes, this is when,
Why were the parties in front of the court on that day?
because it was in a show cause order for failing to follow the court's orders for parenting time.
Okay, so the defendant, the plaintiff, who is
The
filed?
plaintiff mother.
The plaintiff mother has filed a motion for show cause?
No, the defendant father filed a motion for show cause for violations against the mother for failure to follow the court's orders for parenting time.
Fair enough. Do you remember the entry of this order?
Yes.
Now, my understanding is that the parties and the GAL met before going on the record that day, correct?
That's correct.
And that the parenting time schedule set forth in this order, are you done with it? Because
Let me look at it a moment.
that the parenting time schedule set forth in that order was actually agreed to by the parties, is that correct?
Yeah, we worked it out, correct.
Okay. There's also some stipulations put in there that occurred at the hearing. Do you remember the hearing in the case?
Yes, the children should lose certain privileges.
Okay, and who made those rulings relative to were those stipulated to, or were those ruled by the court?
I believe,
Do you recall?
yes, I think the taking away some of the privileges was a direction from the court.
Okay. What privileges were taken away according to R50?
The TV, electronics, if they don't communicate with dad.
Okay, and so directly in that order, if they don't communicate with the dad, we take away their TV, their electronics, and I believe it also says, and visits with friends, correct?
Correct.
Okay. Judge Gorcyca, through this order, essentially grounded these children, right?
To some extent,
Okay.
yes.
This also indicates that, I guess because of a specific problem, if the children do not eat dinner with father, mother is not to provide a replacement dinner. Was that addressing a particular problem?
The problem was they wouldn't eat with him, and they wouldn't touch his food, and they wouldn't do anything when they did go to dinner with him.
And the judge says, much like my mother used to say,
Objection is to,
Sustained.
and
We'll
so
save that for closing.
and so the judge said, if you don't eat with your father as part of these parenting time visits, you're not going to just go home and eat anyway.
Right.
Okay. So again, essentially the court has grounded them this day. The next time they're before the court on a parenting time issue is when? Do you know?
I think it came in, was that March 6th, may I look?
You may look.
I believe. Yeah, it was I filed a motion for a parenting time assessment.
Okay, and when did that occur? I have a March 18th order, so I have the hearing.
Actually, if you look at the back of your Exhibit 50, there's an Exhibit A attached to it, which is in March 4th. The federal motion should
On the back of my 50?
That was the one that was adjourning. That's the same order.
The order, yeah, that was the order adjourning the show cause.
So there's, yeah, then we jump to the next order.
There's a March 18th.
March 18th.
Right, a March 18th order.
Okay.
Emergency review of parents.
And so, have you seen this order? Do you have it with you?
Let me look at that a moment, thank you.
For the record, that's R53.
Right. Yes. And that's when we decided to have the children go to the father's home, one-on-one, with a
Okay.
different child.
So, 2 weeks after this March 4 hearing, you're back in front of the court. Has the children's behavior improved?
No.
Okay, so even taking away the TV, the electronics, even taking away replacement meals isn't helping. The children haven't improved.
No.
And so on March 18th, the order marked R53 is entered that tries to set parameters on how the kids are to be transferred between the mother and the father for parenting time, and splitting up the children for one-on-one time, each with a different child.
Correct.
Okay. Is that, again, the court trying to take control?
Objections to what the court was
Again, you as the GAL felt felt we needed to take control of the situation, correct?
We'll try another thing.
Okay. After that March 18th order, did the children's behavior improve?
No.
Well, on March 18th, there was a contempt hearing scheduled for April 2nd.
Right.
2006.
Did the children's behavior improve after March 18th?
No.
Okay, and so the April 2nd hearing occurs, correct?
Correct.
They come to the court, and I'm trying to find that order. I thought I was much more organized than this, but here we go. By that time, though, there are 2 show cause motions pending, correct?
That's true.
What was the nature of the second show cause?
Well, I believe it was in addition to more parenting time violations that occurred subsequent.
Okay, do you have any memory particularly of what they were at this point in time?
They were outlined in her motion, and I think she relied on the reports from Mr. Gallagher.
According to the order marked R57 and already in evidence, it indicates that the plaintiff failed to bring the children to parenting time 3/23 and 3/24,
Right.
2015.
Now, there was actually an order, which is your R54, on March 23rd as well.
Yeah, I'm aware of that, Your Honor, and that was, that did not have any of the previous stuff that we were talking about, so I skipped over it. But at any rate, on April 2nd, the 2 show cause hearings are scheduled. Does the hearing go forward, or do the parties in the GAL meet?
We met.
Okay, and what was agreed to between the parties, their attorneys, and the GAL?
Okay. We agreed to, Mother agreed that she was in contempt, that she didn't follow the court orders. If I have
Okay,
the
that
word
was
correct.
stipulated in this order.
Stipulated to. I think the Family Bridges was in that one as well. Oh, that might have come later.
Family Bridges is a little later.
Later. And
Family Blizzard was
later, okay.
March 23rd.
57?
Yeah.
Can I have 57?
And that was agreed, we agreed to have Mom turn herself into Judge Gorcyca's courtroom on April 3rd.
I'm sorry, again?
In that order, Mother had agreed to surrender herself for custodial purposes on the Friday, April 3rd.
Did the parties agree on anything else?
And to complete the circle, Chris, that was what Judge Gorcyca was referring to earlier in her testimony about the mother turning herself in, strip search, etc.
Correct.
Did we got it? Okay.
You are listening, we appreciate that. We appreciate it, Judge, thank you.
The parties agreed to tour, Mom and the children could tour the children's village if it was allowable, and that they were going to spend a period of time, a couple of days, in Judge Gorcyca's courtroom from 9 to 4:30, several days that week.
During their spring break.
Correct. And that's basically is germane to that.
Were all of these stipulated to, or were some of these rulings and some of these stipulations?
I believe this order was all stipulated to.
Okay, and so the parties are agreeing that the children's behavior needs to be modified, or it needs to be corrected, am I correct?
Correct.
Objection, that's hearsay, that is not what we ordered.
You were part of this agreement, correct?
For the record, your exhibit 57 is signed not only by plaintiff's attorney, defense attorney, but also by the GAL.
Correct, so all of this is agreed to. This is also a stipulated order.
That one yes.
That the mother is going to turn herself in for a day because she failed to bring children to the parenting time. And that the plaintiff and her children are going to be touring Children's Village.
Correct.
What was the purpose, or what was why did you think, as part of that agreement, that touring Children's Village was important?
Because I think the children needed to know that what it's like potentially to have their freedom taken away if they don't kind of, turn this stuff around. And I know in my report in November, I specifically told the children that in August, that if this doesn't stop, okay, you may run the risk of being placed outside of your mother's home into the village.
Okay, and so is this another one of the draconian measures that you're thinking of? Get the children affected, get the children to know Children's Village because that may be in their future?
Yes.
Okay, this is something that's ordered by the court together with spending spring break, 4 days of spring break in the courtroom, correct? At which Dad can come and conduct parenting time, right?
Right.
So they were again to go tour Children's Village. The prior order about electronics is not been rescinded, correct?
Right.
And they're grounded again for spring break to come into court and sit there, right?
Correct.
After this April 2 order, are we finally getting through to anybody? Is behavior getting better?
No.
Okay. When's the next time you remember being in front of the court on a parenting time issue?
Well, I do know I was there that Friday when Mom turned herself in. It really wasn't a parenting issue. And I believe after that, would it have been in June? I can check the
I
orders.
can tell you, it was June 23. It was June 23.
Okay.
It was originally adjourned over to June 1, adjourned
review
by
hearing.
the court to June 8.
Right.
Then the parties adjourned it to June 23, and that brings us up to the day before the contempt hearing, correct? Yes?
Yes.
Okay. On June 23, the parties are there, and part of that arrangement, or part of that order, is that, again, parenting time is going to be occurring in the jury room, correct?
Yes.
The following day, June 24th.
Yes.
Now, the order from that day says Rowie and Natalie, and then has some later dates for Liam, correct?
Correct.
That's
Okay.
Exhibit 61.
That's our Exhibit 61, which has already been entered into evidence. On the morning of the 24th, who shows up for parenting time?
It's my understanding that Mother showed up with the children and Father
Brought
showed
all
up.
3 children, correct?
She did. I believe so. And Father showed, I didn't get there till later. And then Father showed up. Mom's attorney, Mr. Bosseri, I believe, got there about 9:30.
And when did you get there?
I got there, the reason I was coming there, I got there around 10:30.
Okay, what was the reason why you were coming there?
The day before, Judge Gorcyca, I think Mother made a request to cut the visit short the next day if she could go to a dermatology appointment. I think the judge denied that request. And then I talked with Mom's attorney and I said, well, why don't we show up sometime, Wednesday morning and maybe we can help, facilitate that a little bit. And
Okay.
I don't believe Exhibit 61 was admitted, admitted 1 through 60.
I thought you said 1 through 61.
Yeah, 61, but 61 will be admitted, it's obviously in the order.
It's also a court record.
Yeah, from the court record, correct.
Okay. So you were on your way up to the court when you find out everything has gone south on June 24, correct?
that is correct. Now, there were some voice messages from the judge's staff indicating,
Objection, hearsay.
Sustained.
okay, yes,
Okay, so you find out from the judge's staff, and you're on your way up to the court.
right, there were some
When you
issues.
get to the court, what stage is the June 24 issue at?
I believe at that point in time, the judge was calling for attorneys. It was in the process of the civil contempt.
Okay,
And
so you were
that's-
not there when the judge went into the jury room, and you were not there when the mother read a script to the children, and you were not there to see what the children's behavior was in the jury room, correct?
I was not.
Okay, but when you got there, the judge was calling for lawyers or appointing lawyers,
Correct, and the security, correct.
Okay. What do you do then when you get there?
Well, at that point, I was trying to figure out from various sources what was happening. I know some of the attorneys were coming up that were appointed, and as they came up,
What attorney?
Mr. Schwartz, Mr. Dean, Ms. Cook.
So all three of these individuals have come up to you. What do you think of Karen Cook as an attorney?
Objection relevancy.
Stay.
Are you familiar with Karen Cook's talent or experience level?
Objection relevancy.
All right, how about this? Did you have any concerns whatsoever about, as the attorney protecting the best interests of the children, did you have any concerns whatsoever with the appointment of Karen Cook for NT?
Absolutely not.
As the attorney representing the best interests of the children, did you have any concern whatsoever about the appointment of Michael Dean to represent RT?
No.
As the attorney representing the best interests of the children, did you have any concern whatsoever about the appointment of Jeffrey Schwartz to represent LT?
Absolutely not.
These were attorneys you were familiar with.
Oh, yes, very
And
much
you were
so.
satisfied representing the best interests of the children with those attorneys representing those children's and those children's advocate interests.
No concern.
Okay, fair enough. Did you have an opportunity to discuss the case with those attorneys?
Yes.
Okay, you
briefly.
brought them up to speed, told them what was going
Right.
on, and then you let them meet with their counsel as well. Did you meet with them and their clients at all?
I do know that with the child with the name R,
RT, the middle child.
All right. That mother asked me if she could,
Objection hearsay.
I did meet in the room with the attorney and mother for a minute with RT.
So you took the mother in with RT, did you stay there the
No.
whole time she was there?
I left.
Okay, do you know what occurred in there then, if you weren't there?
Only what Mr. Dean reported on the record.
Then just keep that to yourself, that's fine. Did the attorneys express any concern about having enough time to meet with their clients to you?
No, and as a matter of fact, I believe the transcript, there's a reference that Mr. Dean thanked the court. I think it was Mr. Dean thanked the court for giving him the opportunity, the time needed to speak.
Okay, you saw the hearings proceed, correct?
I was there.
You saw that the court proceeded with Liam first.
Correct.
You were there present for the entire hearing with Liam?
The whole thing.
For all three children?
All three.
But Liam,
Yeah.
of course,
He was first.
occurred first. And you were there during his hearing?
Yes.
Did LT expressly refuse to participate in parenting time on the record?
Yes.
And how did he go about doing that? Do you remember?
I believe he said, I refuse to, I'm not going to talk with him, and I'm not going to
I
participate in
will
parenting
not
time.
talk with him, is what
Right.
he said, correct? Did he ever relent in that attitude during that hearing, to the best of your knowledge?
No.
Okay. That was in the direct view and presence of the court, correct?
Yes.
The court was sitting on her bench in her robe, and LT was before the court and said, I am not going to talk with him, correct?
Right.
I am not going to participate in parenting time,
Right.
essentially, correct? And the court held him in direct contempt.
Correct.
Now you, representing the best interests of the children, did not object.
No,
Why did you not object?
because this courtroom and this proceeding, the judge is in charge of this case. Not the guardian ad litem, not the parents' attorneys, not the children. She took control of this case, and she did what judges do when they swear to uphold the law, okay, and they take an oath. And sometimes they have to make decisions, okay, which are, they have to uphold the law and do what they feel is best. And sometimes it has consequences. But good judges do not at all shrink from that. And she did what she felt
Objection,
was
Your
best.
Honor.
Sustained. Stricken.
Did you have a problem with how Judge Gorcyca handled the proceedings?
Objection as to
Representing the best
relevancy.
interests
It
of the...
is not up to this witness, it is up to you.
Overruled.
Representing the best interests of the children, did you have a problem with how Judge Gorcyca handled these proceedings?
Absolutely not.
Now, Judge Gorcyca described Children's Village as having cells, having concrete or uncomfortable beds, and having no privacy in the bathroom facilities. Are you familiar with Children's Village?
Yes.
Do they have facilities like that
Yes.
at Children's Village?
Yes.
So to the extent that Judge Gorcyca was describing Children's Village, those were statements that, I mean, she wasn't saying, I'm going to put you in the sub dungeon where you're chained to a wall, and she wasn't saying I was putting you in a Mississippi chain gang or something that didn't exist at Children's Village, did she?
No.
She was describing facilities at Children's Village.
Correct?
And now that she ultimately decided to send them to Mandy's place is neither here nor there relative to the truthfulness of her description of the facilities, correct?
Objection that, as to the form of the question, I was
Sustained, it's kind of...
Do you have an opinion about Judge Gorcyca's propensity for honesty?
Yes.
What is your opinion?
Objection, Your Honor. There's no foundation for anything of that sort.
Well, she has testified, but she hasn't been cross-examined, so the question is premature. Right?
So I need to call this witness again?
You may.
Oh, okay.
You're putting the cart before the horse.
Well, it's a strong horse.
I've been called worse things than a horse, but that's okay.
I think he was referring to the judge as a horse, and I apologize for that, Your Honor. In your presence on the record that day, did any of the attorneys representing the children object to the children being held in contempt?
No.
Okay. Did any of the parties' attorneys, now I understand that father did not have an attorney there that day,
Right.
but did the mother's attorney, Mr. Bossery, object on the record to the children being held in contempt?
No. As I read the transcript, I think he wanted to, he made a point to point out to the court that mom did what the court asked her to do, i.e. read the letter, and I think, if I remember correctly, I think the judge acknowledged, yes, she did, thank you.
Are you familiar with contempt hearings?
Yes.
How many contempt hearings do you think you've been a part of as a GAL?
Well, not many as, there have been some in delinquency proceedings and friend of the court proceedings. This was a little bit different.
Okay, this was a civil contempt hearing.
Correct.
You've already acknowledged, right? You
Yes.
familiar with civil contempt?
Yes.
What is the purpose of civil contempt?
To try to have the individual who's found in contempt to purge and change their behavior.
Okay, so this is a prospective order, an order to have the children participate in parenting time. It's not a punishment for a prior transgression,
Objection as to the
correct?
intent behind the court.
I'm not asking for the intent, I'm asking about generally what civil contempt is. It's a prospective order as opposed to a punishment for a past transgression, correct?
That's my understanding. I'm not an expert, but I believe that's accurate.
Okay, well, we already have an expert sitting up on the bench on contempt. He teaches it, actually, so he'll be able to determine that. But you understood this to be a prospective order that the court was entering, correct?
Yes.
This was not a...
Rather than for the past orders regarding parenting time and holding them in contempt for their failure to cooperate in the past.
Right.
Correct.
Correct. Right, the judge was looking that morning, what transpired before, and then it came to the hearing as to the behaviors of the children then and there.
She wanted to improve, I'm sorry, you as the GAL certainly wanted to improve their behavior with parenting time going forward, correct?
Absolutely.
Okay.
Based
And
upon their failure to comply with the past orders.
I'm sorry, Judge?
Based upon their failure to comply with the past orders.
I'm not sure that was my question, Your Honor.
No, I believe it was, they refused the judge's direction to talk. to go to the lunch, and it was that morning is those issues that the judge was addressing.
And those were orders she had issued in the past, correct?
Your Honor, it was continuing parenting time orders, correct?
Yeah.
In the past.
To some
Well,
extent,
there was
yeah.
past and there was future, correct?
Okay.
Right.
Go ahead.
Did you understand, representing the best interest of the children, that the children were given the keys to their own freedom, and all they had to do was participate in parenting time to be released?
Yes,
Okay, and the children were taken into custody, correct?
yes.
Did you have, or were you surprised that the children were handcuffed?
No,
Why not?
because that's the policy of the courthouse.
The policy of the courthouse is to handcuff who?
It happens all the time in delinquency proceedings. It happens even on status offenses. If they're before the court, even if it's a status offense and the court says, you need to be detained, they will go out with a deputy.
If they're taken into custody, they're handcuffed.
Correct.
Can you remember a situation ever where a judge told a deputy not to handcuff somebody?
Objections to relevancy?
Sustained.
It's a normal occurrence for detainees to be handcuffed in your experience?
Yes.
Now, the children were at Children's Village for about 2.5 weeks, is that correct?
2.5, 3, yeah. about that
Roughly.
time, Yeah.
And I understand that you requested the review hearing of July 10, correct?
Yes.
Why did you request a review hearing?
I was seeing the kids every week, and did some reports on it, and we were working with the other attorneys to come up with a plan to move the case forward, okay, to try to help the kids. And I was realizing, after talking with them, that they were not kind of budging, and they were, I don't know if they were enjoying it there, but it certainly didn't look like they wanted to get out. And
So they were not changing their opinions
No.
about their father to the best you could tell?
no.
Okay, and so you requested a review hearing, why?
Because we had a plan to work out, we had a plan that we could present to the court for camp, and until it was sorted out later.
And because contempt was not working?
It was not working at that time.
Okay, and so you asked for a review hearing, had a review hearing on July 10, at which the judge agreed and entered an order removing the contempt, correct?
Correct.
On your recommendation.
Right.
You also recommended, together with the father, that the children be moved to Camp Tamarack,
Yes.
and that was also ordered as well, correct?
Correct.
Okay. Did you have, looking back from July 10 to June 24, was your request for a review hearing based upon your opinion that the contempt hearing should never have taken place in the first place?
Objections to relevancy of what he thought?
Overruled. Go ahead.
I'm sorry, can you repeat the question?
Sure. When you're looking back from July 10 to June 24, was your request for a review hearing based upon your belief that the contempt hearing should never have occurred at all?
Oh, no. No, the contempt hearing was appropriate.
You have no problem with the contempt even looking back in hindsight?
No.
Objections to whether he thinks it's appropriate?
Do you have,
Yes, I understand we're kind of skipping this, but all these are qualified that in your capacity as guardian ad litem for the children.
I'm sorry?
Of course.
Yes.
You're giving your opinion that the contempt proceedings as guardian ad litem for the children was appropriate, et cetera.
Thank you,
I
yes.
understand that.
And so,
But for the record, I need to make sure.
Yes, thank you, Judge. Yes.
how many times have you been before Judge Gorcyca, do you think?
Well, it would be hard to quantify that. I do, take assignments from all of the judges, and
More than you can count?
probably over the last 5 years.
How is her demeanor on the bench generally?
Phenomenal.
What do you mean by that?
I have seen her,
Objections to relevancy?
Sustained.
Does she talk with her hands?
yes, she's animated.
What does animated mean?
I mean, she does. Use her hands.
Okay, so give me an example.
You know, she'll try to illustrate and do, and, yeah.
Okay, and do you think she even knows she's doing it?
Objections to what she knows.
I'm asking if he thinks she knows he... Fair enough. Give me a second, if you would, Your Honor. Your Honor, I referred to a number of hearings that occurred, I believe, on, I think we talked about August 21 already. I also referred to March 4. I referred to April 2. Or March 18, I referred to April 2, and I referred to got my... And I referred to, I'd like to have those exhibits and transcripts admitted into evidence. There are exhibits 77, 78, 80, 80A, 82, 85. Well, 85 is already admitted. So 77, 78, 80, 80A, and 82, and 82A. In addition to the first 60 or so exhibits that we had.
They're all transcripts of the court proceedings, which are a matter of, they are the court records.
I agree.
And I understand what the court's saying about court records. I'm looking at what counsel provided me under 78. All I have is a blank page and no exhibit.
Your Honor, when we provided copies...
I have a DVD.
When we provided copies of the exhibits...
That's fine.
We agreed that we would not have to provide additional copies of videos we knew each other would have.
What's 80 and 80A?
80 is the March 4th transcript.
80A is the video of March 4th, set forth on our second exhibit list, second supplemental exhibit list.
80 is the transcript, 80A is the DVD. 82 is the transcript of April 2nd. 82A is the DVD of that proceeding.
Correct.
85 is already been admitted.
Correct.
And is the June 24th transcript.
Mr. Lansad, at some point in time during the investigation stage of this case, you had a conversation with Paul Fisher, didn't you?
Yes.
Okay. We've already argued in motions in this case about evidence concerning your conversations with Paul Fisher, and I know that the court is not going to let me get into that, but I just wanted to make a record or an offer of proof to the court that if this witness were asked, Mr. Lansett would testify, as we said in our motion, Your Honor, to two conversations.
Again, I have to object. This offer of proof is not a way to get what was...
The offer of proof was contained in your motion to disqualify.
Fair enough.
Thank you very much.
Okay. Anything? Okay, we're all... I'm going to pass the witness at this time.
Cross.
Your Honor, before we go on, I would like a clarification from the court. I know that the court indicated that exhibits, I believe, 1 through 61 were admitted as court records. Unfortunately, among those mixed in are some emails that are not court records.
Yeah, they're just the court records. Well, the emails, I believe, are attached as exhibits to some of the motions.
Is this yours?
That's yours. To the extent that they were not included, those emails would be, as exhibits to motions, they would be excluded.
Okay.
But you, for example, as I was pointing out, there was a couple of things, there were emails, I believe Mr. Ransom, that exhibits to various different, something else that were exhibits to his motions. Go ahead, counsel.
Your Honor, can we take a 5-minute break?
Yeah, I'll let Ms. Renier rest up for.
Let her pack the gun.
Yeah, all right.
Thank you.
Okay, take 5.